gonna happen. But let's now transition to a great success story, and it's one of the counterparts of where you all are going tomorrow is Pupukea. We had a case come through our office for Hanauma Bay. Uncle was out spearfishing, and I'll tell you his defense in a minute, but Hanauma Bay was closed for the day. A groundskeeper was, sweeping the leaves and doing his stuff. And out of nowhere, he sees with no shirt, board shorts, spear over his back, a whole rack of fish, some other, diving gear, and he sees the groundskeeper on Hanauma Bay, and he books it, starts running, hides in bushes, does all sorts of stuff. Groundskeeper doesn't like chasing, but he looks around for him and doesn't see him, but the guy full on jumped into bushes. About 10 minutes later, the groundskeeper is walking through the parking lot again, and lo and behold, Uncle has his spear in the back of the truck, has the fish in a cooler, has all of his gear, his wetsuit and everything. He still has his board shorts on, still wet. And the groundskeeper called the DLNR guys. They came, made a report, filed the report. They issued a citation for illegal fishing in Hanauma Bay. We arraigned him, we charged him, and the guy wanted to fight it. Now it's a serious charge. It's petty misdemeanors for technically each fish that he had caught inside Hanauma Bay. He had about 4 rather large, very nice sized fish. He decided to fight it instead of, like somebody mentioned earlier, the goal is to get people to plead. If they are charged, we want them to plead. But this guy wanted to fight, so we went to trial. His defense at trial was that he didn't know that he was in the Hanauma Bay waters, and that he actually had started outside of Hanauma Bay, but then a shark came and he had to swim into Hanauma Bay just to get back in the shore. What we had to do as prosecutors was to establish, in Hanauma Bay there's 2 things prohibited, same at Pupukea I believe. You cannot attempt to take any fish from the sanctuary area or the conservation area, and you cannot possess devices that would be used to do that. Now, groundskeeper is the only witness we technically have at the moment that this guy gets out of the water and is walking through the parking lot or walking through some ramp area. What we have to do is establish that beyond a reasonable doubt, because this is a criminal case, that this individual obtained those fish from that water and that he used that spear in that water, or he took it in that water. We established through a variety of circumstantial evidence that 1, the spear was wet, his clothes were wet. We established through experts those fish could not have come from likely anywhere other than Hanauma Bay, because that's a healthy conservation area, and those fish are larger in that area than otherwise. We have terrific testimony from DLNR as well as a wildlife expert, and we have a groundskeeper who's just a normal Joe guy, and had a guy who was panting out of breath and we ran away from him. We got a guilty conviction. He got a $500 fine for each fish and was put on probation, 6 months probation. Now, for an environmental related offense, that's a pretty severe penalty, and it's considered a success. The percentage, though, of cases that we prosecute at the City and County of Honolulu is very small compared to, like Alexa said, murders, thefts, rapes, driving offenses. The ultimate story, though, I think, that I talked to my buddy who actually prosecuted that case, and him and I chatted about it while I was going through it, and the trial took about 2.5 to 3 days, which is a long trial for a district court case. But he said that after the fact, the guy got found guilty, was given probation, and he went on a blog after a diver's blog, and he apparently said, you know what, they got me. Because he denied it the whole time. And then after the fact, after he was finally found guilty, he said, you know what, they got it, I did it, and you know what, I shouldn't have done it. Now that kind of a realization, and especially to go to a community blog and say, hey, they did prosecute me, I'm on probation, I have a criminal conviction now. And because he went to trial, it will always be on his record. He will never get to expunge that. That's one example of, a little bit more of a serious, successful prosecution, how it was done through work with the parties, through good prosecuting attorney work in which we talked to our witnesses, we went out and we tried our best to prove to the judge that this was serious, that this was not good, and he needed to be held accountable. Other examples of successful prosecutions that are simple. Like I mentioned, illegal hiking. The penalty is severe for a kid who just wants to go on a hike. It's a year in jail. Now, as a prosecutor, you have to have discretion to be able to say, hey, should I amend this to trespassing and will they not do it again? You see them again come in for it, then you stick it to them. Those are the options and flexibility you have, and it keeps the resource safe because you're not having people trample through areas that are supposed to be closed by DLNR or by the state. I had a handful of cases in which I was doing the lay netting, gill netting. Those cases are a little bit more difficult to prove because possession of it is one thing, and it's a strict liability. But then the issue with the statute is it can only be 2 inches for the hole in the net. Each hole, when you stretch it out, it can only be 2 inches. So then the argument in court is, oh no, it's 2.5 inches, or it's bigger. Those types of complexities are important, and that's why we have the DLNR officers or the state experts that are able to say, no, I know this type of fish is prohibited during this season, or in this specific area. How we alternate certain fishing options on certain days. Other very basic examples of prosecutions is that once they come before our desk, we'll probably get maybe, I'd have to think about the statistics, but thousands come in every month. I would say maybe a couple dozen DLNR citations might come in a month, if that. So the importance of trying to encourage either the prosecuting attorney or the attorney general is through communication to say, hey, this is important, and if you take time on your reports, we take time in looking at it and deciding how we can prove it or charge it. With many of the cases, such as guys going out to Moku'ua Island or out to Rabbit Island, or any of those other little islets offshore, many of those are closed to the public. But we've had cases where either private citizens or DLNR officers are on shore patrolling, and they got the guys, we got clear, zoomed-in photos of them cruising on the beach enjoying a beer. And those can plead out because all we got to do is show the defense attorney they were there, they weren't supposed to be. So those are all examples of successful, done, everything is done. They take responsibility for their actions. I think the goal, though, that all of you all are hoping for is that you don't have to get out there every day trying to keep people from doing bad things. In many cases, in our community, you have crime occurs. People hurt each other, people steal from each other, people assault each other, people make bad choices and drive when they shouldn't drive. With the environmental stuff, most of the people that are doing the illegal conduct do it because they know it's illegal and they try to get away with it. The goal, though, I think, of everybody here, and I just stepped in this morning, but it's ideally to have people not break the law, to have people just respect the resource and to know that this resource should not be violated in this way. I think a good example of successful, not even prosecution, and it couldn't have been a failed prosecution because they didn't get to that point, is what DLNR did with the sandbar, in which they went about it through their own mechanisms, through their own internal structure, and they didn't involve the city government, they didn't involve anybody else except DLNR. They said, we need an emergency rule to protect the resource and to protect people from hurting themselves out there by boozing out on the sandbar or doing other illegal activities. What they did is they said, okay, 3-day weekends, no drinking, no debauchery out there. Now, when that happened and DLNR came down with its emergency rule, my office's response, and I wasn't involved in this because it's the highest man on the totem pole, said, we're not prosecuting them. If you issue those citations on a 3-day weekend, give it to the AGs. We don't want to do it. AGs are like, oh, we're overstaffed. everybody passes the buck. But at the end of the day, thankfully, unfortunately, and I think what is shown now 8 months later, what happened? How many citations have been issued? Only a handful and none to show up to court. So no agency was overburdened because DLNR didn't have to issue the citations. Now DLNR is trained and prepared to do that, and the threat of that enforcement, the knowledge that you are not allowed to drink out of the sandbar, people respected that. And it was, I think, a huge success, which didn't overburden any other agency. I think that's, I guess I can answer questions. I think I touched upon pretty much what I was hoping to touch upon. Does anybody have any questions? With regards to the work you all are doing in the conservation area tomorrow, I'm sure they've talked with you about it already, but that is one example. I believe Professor Antolini from University of Hawaii was part of a hui or a group that really spearheaded that effort, and it is a sign of success. Same with Hanama Bay. The ability for the government and the community and everybody to interact and work together towards one goal of everybody being on notice and everybody being on the same page towards the same goal. It shows that Upukea has now flourished, Hanama Bay has flourished, and it's just towards that end that you guys want to push. I think at the state level for the state of Hawaii, the mechanisms are in place, and the goal would be to leave the criminal side of it, where it comes into my office and I have to decide whether I charge somebody with a crime. Leave that to the serious offenders. Leave that to the guys who really, really deserve it or who have abused the resource too much. There needs to be an option for administrative side through like what Alex was talking about, the civil side, because that gives you flexibility at your either agency level or state level to be able to say, hey, you're not going to jail, but you're going to pay a fine, and guess what? We have other punishments if you don't pay your fine. We may not let you get your license renewed. We may take away your permit. We may do all sorts of things. Those types of mechanisms are a lot more effective for these types of crimes, I believe, but it is very important, and I think Hawaii is good in this sense that we do have laws that protect. It's just a matter of pushing and communicating and really getting your voice out there and saying, we care about this. Please take this seriously. Yes?
You said that our state laws and rules are set up for criminal prosecution, not civil.
Mm-hmm.
So what is it going to take?
Okay, well, the state laws are set up for criminal, but the state laws are also set up with a mechanism to allow for civil. Meaning, if there was, the goal would, I think in two senses. One would be you have a civil and you have criminal, or administrative and criminal. Those two basic tiers, the criminal law is set up. It provides for criminal penalties, a misdemeanor, a felony, a petty misdemeanor for possessing 6 akule or whatever it is. The administrative side, that mechanism is already created, but you have to have the entity within DLNR or the entity within the court system that understands itself to be an administrative court. And all you have to do is just set up, the rules just have to be slightly tinkered with, where you would add a new rule and you set up the type of civil enforcement mechanisms that Alexa was talking about. It's already there, and it's just a matter of at the point of violation, when DLNR or a law enforcement officer is looking at something, he only has one choice right now, pretty much, is to go criminal. Issue him a citation. That's the only way he can hold this person accountable. He can have another option, and that option, the mechanism is there, you just got to create the tail end of that path. So it's there, and the law would still be the same. You can still prosecute for the same crime that I would prosecute in criminal court. You would just prosecute it or proceed on it in an administrative setting. And that option is there because the statute's set up in a way you are subject to criminal or civil liability depending on what the officer or the charging person decides. Does that make sense?
Yeah, but whose job is it to put the tail on?
I believe people are already endeavoring to push that in various ways at the legislature over the last couple of years. There has been discussion and bills that have been discussed thoroughly about further administrative empowering DLNR and not necessarily, DLNR has the power. The issue is saying to the agency that, you have the state legislature and this government agency saying, go for it. not necessarily saying, here's the power, do it. They already have the power, but they're hesitant because they don't want to, you know, rock the boat with the higher ups and the legislature and stuff. So it's kind of like the legislature saying, we think that's a good idea, go with that. So it's a whole effort from the top down saying, you know, if Governor Abercrombie wanted to say, Chair Aylott, I want you to push on this, make this a priority. You know, they're taking steps, but it is through your government, through your executive branch, legislative branch, and your agencies, all the way down, that will make that successful. And it behooves the agency, because if you go civil, you get all the money. Otherwise, it ends up in our state coffers as opposed to with the department.
I was just wondering about the details of two cases you talked about. You said one when they came off with the mahi-mahi, and you couldn't prosecute it because you couldn't prove that they had actually caught the fish. And then the case in Hanauma Bay, you said, you know, that you could prosecute it even though you hadn't seen him fishing. So is it just the difference that in his case his spear was wet and that was enough, or was there something else going on because it was commercial versus recreational or something like that?
A couple things are going on. One is the commercial license aspect of it, in that the charge that he was charged with by the officer, and I looked for other laws that I could prosecute him, but mere possession of mahi-mahi is not going to be a crime. What is a crime is fishing without the license. So the element was that we have to prove that they fished, actively fished, not merely possessed. With the Hanauma Bay issue, same principle. The statute or the rule that provides for the conservation district clearly establishes you cannot fish, take, attempt to fish, attempt to take. We would still technically have to prove that he shot that fish in the water. But through circumstantial evidence, we were able to say, Judge, there was nowhere else he could have caught this fish. We know he caught this fish, and we are proving to you that he did. You know, his conduct, his exasperation, his running, the spear being wet, the size of the fish from that location, it would have been ideal if we could see him coming out of the water with the fish. But we did our best to connect the dots and not say we give up. This guy wanted to fight. He fought all the way through trial, and the judge threw the hammer at him after. But in the end, I think the great pearl of that story is that he acknowledged after he said, they got me, and you know, we shouldn't do that.
Just wondering, has there ever been an attempt by the prosecutor's office or by individuals in the prosecutor's office to meet with people higher up in DLNR, either in the chair's office or more appropriately perhaps the administrators of DOCARE and DAR, to talk specifically about what you've talked with us about today in regards to, you know, here's why your rules aren't effective in terms of us making cases, and here's what we need you to do to change those rules, because they are changed through the, at least within DLNR, through rulemaking. It's done by the division. So unless that feedback gets to those people directly, these rules aren't going to change.
And I completely agree with you. I hear you loud and clear. I cannot speak for the prosecuting attorney's office. I can share that, no, those meetings don't happen. They're not pushed. They're not made a priority. Now, domestic violence is a serious issue, but environmental protection is too. We at one point did have a person, an environmental person who oversaw all the environmental crimes. Not anymore. Those meetings need to happen. And it's at the top level, but it's also at the level of me as a district court attorney handling it and saying, hey, let me ride out with the DLNR officer and see what we got going on. Because we go on ride-alongs with the DUI squad, we go on ride-alongs out in Waikiki, we walk the street with them. The same thing can happen between DLNR and the prosecutor's office. It's just a matter of pressure. For the sandbar issue, I showed up because of a good friend and colleague was part of it in the discussions when they were talking about it. And I said, I'll be there. My office didn't show up, but I showed up, and it was clear, I made it clear, I'm not representing the office, but here's my input. I was happy to do it, but the formal discussions need to happen, for sure. It's just a matter of pressure and persistence, because I think those meetings are very valuable, such that you just basically make it clear to the prosecuting attorney or to the higher, the attorney general, that, hey, we take this seriously, we care about it, what can we do? And I gotta tell you, for the reports that I dealt with hundreds of DLNR reports, out of thousands of others, they were pretty damn good. And DLNR guys and the enforcement guys, they care about the work they're doing because they know that these reports aren't just like any other police report. I think the good faith and effort on the part of the environmentalists is there. I just think you need to coax and persist and push on the prosecutors just to get one guy or get a few guys and get that open communication going, because they'll care. And the reports are good already. There's not